The Supreme Court will rule next week whether to compel opposition leader Raila Odinga to participate in the October 26 repeat election. The case filed by a Jubilee-affiliated member of parliament was heard conclusively without Odinga's participation after the latter declined to file any response in court. And as Murimi Mwangi now reports, the case proceeded as yet another petition was filed in court seeking to suspend the repeat election.
As National Super Alliance supporters took to the streets for the fourth week in adherence to opposition leader Raila Odinga's campaign to boycott the October 26th repeat poll, Jubilee elected Pokot South legislator David Kosing asked the High Court to issue orders blocking Odinga and his running mate Kalonzo Musyoka from quitting the repeat election to prevent the country from sinking into a political crisis.
A litigant who succeeds in court and says that I want this relief, and that relief is granted, then you are bound by the court giving that relief.
No citizen and the law can never compel anyone to run or participate. That is a choice consciously made by the citizen, and the law allows him to do so.
The court had early last week ordered Odinga to respond to the petition in 4 days, but neither Odinga nor his lawyers had filed any papers as the matter came up
From the top,
prompting the court to proceed without NASA's input. The judge will deliver a verdict on Tuesday next week, which will be only 2 days to the repeat poll. Separately, former Kilome MP John Harun Mwau has asked the High Court to suspend the repeat poll altogether on grounds that electoral body IEBC and Chairman Wafula Chebukati did not conduct any nominations prior to gazettement of candidates for the repeat poll, a move the former MP argues could see the presidential election nullified yet again at the Supreme Court for violating the Apex Court's order that the fresh elections should be conducted in conformity with the Constitution and the applicable election laws. Mwau's case comes barely a week after the High Court ordered inclusion of Third Way Alliance leader Dr. Ekuru Aukot to the list of presidential candidates that initially only featured Odinga and President Uhuru Kenyatta. A ruling that prompted IEBC to also gazette names of other fringe candidates from the nullified August 8th polls. But the spotlight on Tuesday turns back to the Supreme Court, where the Chief Justice David Maraga chaired 5-judge bench will rule on the IEBC chairman's role in verification of presidential results.
I urge that you should incline towards granting the clarification that is sought as we go into the elections.
To suggest that there is some law that empowers the chairperson of the appellant as an individual to alone correct, vary, confirm, alter, modify, or adjust the results electronically transmitted to the National Tallying Center from the constituency centers is to donate an illegitimate power.
Chebukati filed the petition after the nullification of President Kenyatta's re-election, saying the Supreme Court verdict had contradicted a recent appellate court ruling in a case filed by activist Maina Kiai, where the commission chairman was barred from verifying or altering contents of results on Forms 34A and 34B. Murimi Mwangi, KTN News, Nairobi.